All of a sudden, you're faced with an application or a granted patent where the disclosure includes patent eligible subject matter, but because of the way that you claimed it 3 years ago, it would no longer stand up in court.
Sri Atluri is the Chief IP Counsel of Walmart.
So honestly, that is the thing that I worry about, because I want to make sure that my claims, my patent applications, my patents will stand the test of time.
Welcome to Clause 8, presented by TradeSpace, a revolutionary end-to-end AI-powered IP management platform that helps companies unlock the value of their IP. If you enjoy this show, please take a minute to subscribe on clause8podcast.com. As the head of Walmart's IP team, Sri sets the vision and strategy for reducing the company's IP risk and protecting its most valuable innovations.
It is 100% worth our time and money to enforce our patents. When we see our technology being infringed, I think we have an obligation to protect it.
And now, here's your host, Eli Mazour.
Sri, your job title is Chief of IP Counsel. When you think about your role, what comes to mind? What is your actual responsibility at Walmart?
At the highest level, in my mind, my ultimate goal for Walmart is to reduce our IP risk in whatever way we might see it across all of our businesses. Certainly, when we're thinking general merchandise, I'm thinking reducing our trademark and copyright risk with respect to our private brands. When I'm thinking about sort of our interactions with our partners, our suppliers, our vendors, any third party, I want to make sure that we are acting in an environment where our IP obligations are clear, where it's understood who owns the IP, who's bringing what to the table, so that we aren't left with any misunderstandings. And then certainly I'm thinking about sort of Walmart's overall mission and its mission statement, which is that we are really a people-led, tech-powered omni-channel retailer that's dedicated to helping people save money and live better. And I think about that because I love how tech is really baked into that mission statement. And so I am very cognizant that it's on my team to make sure that we're actually protecting the tech that's powering Walmart.
I'm guessing from what you're saying is that Walmart comes up with some unique technology to serve consumers. First of all, what do you mean by protecting it, and why is that important?
There are a lot of different factors when I think about what we need to do to protect our innovation. First, I want to make sure that we're really thinking about who needs to be using it and that it's accessible to everybody who's using the services that Walmart offers. And so making sure that any improvements are accessible to our vendors, our suppliers, all of the folks that we really work with to make Walmart what it is. I think in the strictest sense, when you're talking about protecting IP, we all, especially big tech companies, tend to think about making sure that we're filing patents. And I think that's absolutely important. That is a key piece of it for sure, for all of the reasons that go along with why people might want to be filing patents. Certainly, I think it provides a deterrence factor with respect to litigation by competitors and others. In addition, the way that I like to explain it to my clients within Walmart is that if we're not protecting the innovation that we are spending our money on developing, then we're essentially donating our R&D dollars to our competitors. And so that for me is an incredibly important reason to be protecting our IP. And then just in terms of the Walmart brand, part of the reason why Walmart is where it is just because of the recognizability of its brand. So I feel that responsibility every day when I'm thinking about how we're adequately protecting Walmart, really making sure that we are thinking about what we need to do to protect its brand around the world, protect not just its flagship marks and house marks, but also all the private brands that people really associate with Walmart, like Great Value and Equate and so many others.
When others think about your role within the company, you mentioned already some conversations you were having, I'm sure, within the legal department and maybe outside within others, within the engineering and so forth. What are they concerned with? Or is it kind of something that they leave it for you to worry about?
That's a really good question because it can be all over the place. Having come from a larger tech company, I think there was a very patent-centric understanding of intellectual property, and people should immediately off the bat, for better or worse, the importance of filing patent applications. Here at Walmart, I really think this is a newer idea for many of the folks at Walmart. That being said, like I said, it's now baked into our mission statement that we are really a tech-powered retailer. And so I think from the highest levels, there's a real understanding that if we don't view ourselves in that way, then we're not going to be able to compete in the e-commerce arena because there's such a recognition of its importance by our CEO and at the highest levels. That has, a trickle-down effect. And I think we're starting to see that awareness continue to grow across the company.
And I want to dig a little bit into how you think about your patent portfolio corresponding to innovation. I was actually looking at the most frequent inventors in the US. Not surprisingly, the inventors who name shows up most often on patent applications in Arkansas work for Walmart. Obviously, Walmart is one of the most important companies in the US, even a more significant company in Arkansas. And then you can see that kind of correlate to that. But I want to, there's innovation going on. Technology innovation is an important part of Walmart. How do you think about building a portfolio that is worthy of that or represents that or meets the goals that you described earlier?
I really want to be led by the company's strategy in that respect. One of our goals is to make sure that we are forging the connections within Walmart that will help us make sure that we're being strategic in terms of the patent applications that we're filing. So what that means is certainly, like so many other big companies, we have a patent committee staffed by subject matter experts that have their finger on the pulse of what is happening inside Walmart. We, on my team, really look to make sure that not only are we reaching out when we know that there is a project that our associates are working on, but that we're also reaching out when we haven't heard from a team recently. I think there are so many instances where there might be innovation happening that we may not always hear about. And that's one of the things that honestly, I think tends to make me not stay up at night, but certainly worry me a little bit that there are pockets in the company, a company the size of Walmart that we're just not quite getting to or haven't heard of. And so part of that is really raising awareness amongst all of our engineering populations in particular, but our general associate population across the board, to make them aware that we exist, to cultivate those relationships with folks so that if there is something going on, we'll be made aware of it.
And it seems like a very organic approach. Obviously, you hear other companies, they do other things. For example, they look at their competitors and say, there's just an example, Walmart might look, Amazon has, 10,000 patents or whatever. Should we try to match them? Or they say for an amount of revenue that we get from this, technology, we want to get the X number of patents or so forth. Do you apply any such strategies?
What other people are doing is always interesting. If you're not keeping up on what your competitors are doing, if you're not aware of best practices in your particular practice area, then I think you're falling behind. That being said, my goal for Walmart has always been for us to forge our own path. I think that it is easy to get caught up in a numbers game and say, hey, they've got X number of patents in the AI space and Y number of patents related to platform technology. To be honest, that has never been something that has concerned me. In my mind, so long as we feel protected in terms of the strategic areas that we are moving forward in, so long as we feel that we have the room to operate and are protecting what we're doing, I feel like we're doing it right. I feel like we're in a good place. When I'm thinking about the size of our portfolio, part of what I calculate or take into account as I'm thinking about that is really Walmart's EDLC ethos. And for those of you who might not be super familiar with all of Walmart's acronyms, EDLC is everyday low cost. And that's not just something that is consumer facing. I mean, that kind of permeates everything that we do. And so that's part of what I think about is, look, I'm not just going to get assets and pursue patent assets for the sake of pursuing them and to be able to say, oh, our portfolio is 10,000 strong. That to me is really far down on my list of priorities. What I want to be able to say is that, hey, in this particular strategic area for Walmart, whether it be our mobile app, whether it be our exit technology or our point of sale checkout technology, I want to say I feel good that I have the assets necessary to operate in that space, to cover what I'm doing, to prevent others from doing what I'm doing, and just room to maneuver. So that's how I think about it, to be honest. There are so many services out there that give you a million different dashboards where you can click down to the nth degree. And that to me feels like information paralysis, like so much information that is ancillary to what I think is truly important for Walmart. And what I think is truly important for Walmart is, I hope, guided by all of the senior leaders at Walmart and the direction in which they're going.
You want to just feel good that you have the protection that you need. I mean, the problem with patents is that there's no such thing as a perfect patent or knowing a perfect level of protection. What makes you feel good that you do have that protection? How do you think about that?
One of the things that we always do as we are applying for a patent, prosecuting the patent, once it's been issued and we're looking at every milestone and making decisions as to whether to continue to pay fees on that patent, is we will ask our business, how are you using this technology? Does this technology still describe what you're currently doing and your future direction? And really based on those answers, that helps identify for us what we want to do with that technology, what we want to do with that patent application. Do we feel like we're covered? In those discussions, often inventors will tell us, yes, this covered what we did in version 2.0, but now we're on version 3.0, and then we have an opportunity to think about filing a new patent application. So that's part of the process for us. The other thing I think that's really important for us in terms of thinking about what we want to file on is we'll really look at not just what are we doing today, but what direction do we see ourselves going in, so that we can make sure that those are the areas in which we're really looking to patent. I don't know that you can future-proof sort of your patent portfolio. I don't know that I could say with 100% certainty that sure, we've got the room to maneuver and operate, but what I feel certain about is that we have protection on the things that we are doing today, which to me, sort of one of the most important things for us to be able to say. I guess the one thing I will say in terms of the importance of looking at others and maybe what our competitors might be doing, it's not to say that I'm not going to take advantage of interesting new techniques or patterns of protection that they might be taking advantage of. I'm thinking maybe interesting uses of design patents, or there are all sorts of new things that people do, and I think I'd be remiss in not saying that we always want to make sure that we're taking into account best practices across the industry, innovative new practices across the industry. Those things are important, but in terms of letting that lead what we're patenting or letting that drive Walmart's strategy, never really been how we've done it.
Obviously, there's lots of reasons to obtain patents for marketing and so forth. Are you trying to obtain patents that are enforceable? Or are you just trying to obtain enough patents that, how do you think about that? Like each individual asset versus the collection of assets that you have?
Yeah, that is a really good question. And I think it has to be a mix of a lot of different things. To be honest, in the e-com space, if I said we will never file a patent application unless the technology is readily detectable, then we would never be filing any patent applications. It's just that it is just the reality of it. So it's a little bit of a balance. That being said, we have so many assets in areas that, certainly, for instance, in the automation space when it comes to supply chain or exit technologies, where we don't necessarily have that issue. They are detectable, they are enforceable. We have litigations currently where we are enforcing our patents against competitors, and that is, look, we want to use our patent portfolio for all the reasons people want to use a patent portfolio. And so that's important to me. I think making sure that we do have enforceable patents that we're able to detect when someone is actually infringing our patents, that's certainly important. But I do think that in the spaces that we play, when we're talking e-commerce, when we're talking about our world-class supply chain processes, some of these things may not always be detectable, but we do want to protect them for sort of a whole host of reasons. Part of that being that I do think it's important that we have a portfolio of assets so that if we are becoming aware in one way or another that someone is infringing our technology, that we have something to turn to.
Some people listening to you might be surprised to hear that Walmart is actually enforcing their patents, because for a long time, big companies, they get a lot of patents. They don't know what's really in their patent portfolio. They say they get them for a defensive portfolio. And to them, I guess their sense is it's not worth our time, or they say enforcing patents is wrong, or whatever it is. Is it worth Walmart's time to enforce patents, and why is that?
Absolutely. It is 100% worth our time and money to enforce our patents. When we see our technology being infringed, I think we have an obligation to protect it. If we don't, then we're ceding our forerunner status in an area. And I think there are so many areas where we really are on the kind of bleeding edge of technology. And so it is, in my mind, incredibly important that we do that. I am blessed to be at a company that agrees and finds that important, that isn't scared of standing behind its assets when we're able to show them that we do think there's an infringement happening. I'm blessed to work with a litigation team that is second to none and willing to work with us to do that, and believes in the patents that we have prosecuted and obtained. And yeah, I think it is incredibly important. And I think there has to be the will to do that from the bottom up and the top down. It has to be sort of a company mindset. To be honest, that's not necessarily where Walmart ever wants to be. We want to work with whoever it is to sort of resolve our differences and issues amicably. But if we're not able to do that, then we've got to stand behind our technology and our assets. And I'm so grateful to be at a company that does that. Because if we weren't willing to do that, I have a hard time understanding why we're spending the money that we're spending on our patent portfolio. Sure, the deterrence effect, that's great. But it's really hard to prove a negative. And so I think it's incredibly important, and I feel lucky to work someplace that believes in the patents that we've obtained for the company enough to put their money where their mouth is.
What do you think about it? Is it the ethos about Walmart, or the confidence that Walmart might have in its patent assets that others don't?
Gosh, I think different companies operate differently in terms of how they think about their patent portfolio. And there's no one right way to do it, right? And it really depends on what type of company you are. Certainly a tech company like Apple will have a different set of patents than a retailer like Walmart, or maybe a company that's focused more on R&D and licensing. So it's really hard to say whether there's one right way or path to do things or to think about your patent portfolio. In my mind, I want to make sure that our patent portfolio is multifunctional. I want it to provide us with benefits with respect to all of the reasons one might think they need a patent portfolio. When I say that we are going to go ahead and enforce our assets, I mean, we don't have 50 suits out there where we've got no massive campaign. We're not one of those types of companies. That being said, we're not going to be scared to use our assets when we absolutely need to. So I think the first thing to do when you're really thinking about how to build a patent portfolio for the company that you're at is to make sure that you understand the company that you're at. What are they looking to do? Where are they looking to go? How much money are they willing to spend? And then you need to right size your tactics to take all of that into account.
Another thought that comes to mind, you said you prefer not to be involved in litigation, right? That's a last resort. And you've been doing this, I think, about the same number of years as I have. And have you seen that change? There used to be a time when if they have a patent, it looks strong, it was enforced, then the other side might be more willing to settle or kind of work with you, and then it changed over time. What are you seeing now? What is your kind of sense, at least in your industry, about when people find out that Walmart has patents covering technology XYZ?
I think leverage is leverage. I think it was important 15, 20 years ago when I first started. It remains important now. I think whatever that leverage is. In the patent space, certainly it is patent assets, patent applications, a nice sized portfolio. I think about it similarly when I'm thinking about in the trademark space. Registrations are helpful. They are leverage. And I don't know that I would say that they've decreased in importance or increased in importance. I've certainly seen them be used differently. I mean, I started in the dark ages before there were IPRs. And back in the day, maybe you could file a one patent litigation and feel pretty good about yourself. I don't know if you can do that anymore. And so I think people sometimes feel like they need to have a nice family of assets, several different assets that they can throw at someone so that you're not just setting yourself up for an IPR. Certainly makes it more difficult when someone asserts 8 different patents. It's a lot more expensive to file 8+ IPRs. And ultimately, though, having a patent portfolio, having an IP portfolio in general gives you leverage in a whole host of different situations, certainly when you're faced with litigation, but also when you're working with the types of partners and vendors and suppliers that we want to be working with on generating best-in-class solutions to some of the problems that we face. I think if we didn't have something to rely on or some experience of our own when we're looking to come up with AI solutions with some of our partners, we would have sort of a scarcity of partners that have experience in that space to work with, because they would think, well, Walmart doesn't know what they're doing. So I think it's important for a lot of different reasons. And I don't know, maybe the leverage has changed, but I don't know that it's really become less important over my career.
That's interesting. You point out that maybe what you need to have to be taken seriously has changed. But if you have what it takes to be taken seriously in terms of the number of patents or the strength of the patents, that still provides you with the leverage for that. One thing you mentioned is e-commerce, right? And when you talk about e-commerce in the patent space, Section 101 and patent eligibility issues come to mind. I guess I want to talk about it on both ends. In terms of obtaining patents, What are you seeing? What is your experience with trying to protect Walmart's innovation at the U.S. Patent Office?
In my mind, I think the best thing we can have in terms of subject matter eligibility, Section 101 issues, is certainty from the USPTO. So that's honestly my gold standard, because what I worry about is that we have patent eligible subject matter in a disclosure. We've written our claims pursuant to the USPTO's guidance as of 2 years ago for an allowable claim. And patent practice evolves over time. 3 years later, the USPTO no longer wants specific language that might have made your claim allowable 3 years ago. And all of a sudden, you're faced with an application or a granted patent where the disclosure includes patent eligible subject matter, but because of the way that you claimed it 3 years ago, it would no longer stand up in court. So honestly, that is the thing that makes me nervous, that I worry about, because I want to make sure that my claims, my patent applications, my patents will stand the test of time, that it's not going to be something that we were able to get past the USPTO one way or another, or get past a particular examiner because that's the language they like, but then can't do anything with it. So in my mind, certainty is the best remedy, whichever way it is. I think that is really what I'm always looking for in terms of thinking about patent eligibility and Section 101 and the technologies that we play in and find ourselves trying to protect.
From what I understand, you're saying is that it's not even that you're concerned about not getting patents. It's your concern is more if, yes, you can get patents, but you just don't know if once they're enforced, if the courts are going to reach to that same conclusion the examiner did when he decided to allow that application in terms of patent eligibility.
Yeah, that's honestly what I worry about. Look, if I know where the law is, we will figure out a way to make sure that we're writing things in the way that they need to be written, right? I think for me, it's really just knowing where we need to go. And there's all sorts of different techniques that we employ to try and make sure that we are safeguarding our patent assets, that we're not falling into some just add this language trap. But it's still, that's the piece that I sometimes worry about. I feel like every couple of years in this space, there is new guidance. We're talking on the 17th of July, and there was new guidance from the USPTO just today. I think
the new AI guidance, yeah. New examples. Yeah, it was
new examples, yeah. I don't know if that really changes anything, but I just worry about making sure that when you have patent eligible subject matter in an application, that the way that you claim it isn't necessarily going to preclude you from the protection that you should be getting.
Correct me, I don't want to speak for your behalf, but it seems, at least my sense is that there's some gamesmanship involved right now, right? If you capture the idea in a certain way and you describe in the patent application, if you talk to the examiner a certain way and you do what he wants, you might get a patent. But it's really, because everything is so uncertain, it doesn't do anybody any good to play these games. I'm talking about the system as a whole, not obviously. If you need patents, you need to do what you need to do, but I'm talking about the work that's required to protect the innovation that you're investing in.
Yeah, and I don't think that's the intent of the USPTO by any means. I'm not at all attempting to suggest that, but I think sometimes when you're operating in the gray, that can happen.
Yeah, and they're boxed in obviously by what judges are deciding along the way. At least the guidance that came out yesterday, they're citing cases. I want to talk about obviously your in-house counsel, but you started as a law firm attorney. Anything you can share about your view of that relationship, any kind of wisdom that you can share that now you're a Chief IP Counsel that you wished you knew when you were starting out as a law firm attorney, about what you might be looking for, what kind of value could be added by outside counsel and so forth?
I think maybe a misconception that I had as in private practice when I was working with in-house attorneys was that I thought I just had to provide them with the black letter law. And I don't know that I always appreciated sort of the analysis that happens on the other side. I mean, we're talking about operating in the gray right now with respect to Section 101. Basically, in every aspect of the interesting decisions that I get to make in-house, I am basically operating in the gray. If there were black letter law on something, if it were a black and white decision, it would be easy. You wouldn't need a team of IP attorneys. You would just say, do this, right? And what I've realized being in-house is that so much of what I'm doing for my clients is saying, there is no black and white answer. What we have to do then is really look at the cost-benefit analysis. What are the risks? How likely do we think that we will fall subject to that? And what are the risks in not acting and not letting the business move forward in a particular direction? I wish in private practice I had better understood that so that I could help my clients really get to a decision. I think I see this now actually so many times where I'll ask, my outside counsel, can you help me make this decision? And what I get back is a memo. This is the case law that said, this is the case law that said that. But then there's we are not doing either of those things. We're somewhere in the middle. Like, how risky do you think it will be if I do this?
So what do you think? They're scared to make a recommendation?
I don't know. Maybe they are. And maybe they're just being smart. Maybe they're being smart of covering their butts. And maybe that is the calculation that they're making. But I think what I wish I had known was that, basically that, because I think I would have been a better outside counsel to my clients if I could have said, I know that this is the situation that you're looking at and there's no good answer, but I can tell you why you might want to go in this direction versus why you might want to go in another direction. And it just feels like that's where I operate all the time now. And maybe that's just the difference between being in-house counsel and being in private practice. You don't have to do that. You just get to say, this is what judges have said when this happens. This is what they say when that happens. Personally, I think it's the fun part about being in-house. I think it makes things interesting. I mean, I'm thinking about applications of generative AI right now. There is no answer. And so that's what we get to do is we get to say, if the client wants to use generative AI in this way, how likely do we think that's going to be a transformational use when we're talking copyright? Or do we think it's a derivative work? And how all those things, they make it fun, they make it interesting. And there is no right answer necessarily, right? The courts haven't told us. So we get to say, this is me forecasting into the future where we think the courts will go, whether we think Walmart's going to be a target. Walmart's always a target.
Makes your decisions real, right? Not theoretical. A related complaint that I hear in the patent portfolio development space related to a subject we talked about is clients send out invention disclosures related to subject matter that obviously has Section 101 issues, and the outside counsel comes back and says, this has Section 101 issues. And they're like, we know, that's why we're sending it to address that and to make sure we avoid that. But yeah, I think it's an interesting psychological question about the fear. I guess, lawyers are probably more risk averse than most people, and then maybe that kind of drives their behavior.
So maybe I was being smart in not telling my client. So yeah, now I'm looking at what I was doing in a whole different lens.
No, but if you're trying to bring value to clients, I think that's very valuable advice that you're providing. What about in-house? You mentioned, I think you were at HP before, you were at Walmart, and now you're Chief IP Counsel, which is a dream job for a lot of people. What advice would you give in terms of how do you succeed in-house? I think you hinted maybe a bit about being willing to take positions, but what other advice would you give maybe to somebody taking the first in-house job and kind of starting out in that journey?
I would definitely say don't be scared to try new things. When I went in-house, I had been an IP litigator for about 10 years prior to going in-house. And then when I went in-house, I went into HPE on the patent portfolio management side, which was really pretty different than what I had done previously. But that's what I would say. Don't be scared about trying something different. If you have an opportunity to maybe be a business attorney for a functional unit inside the company, go do that for a little bit. If you have an opportunity to do IP transactional work or just contract work, do that. I think being in-house really provides you with the ability to do a whole bunch of different things, which can sometimes be difficult to do when you're in private practice and more senior. Nobody wants to pay a partner or an eighth-year associate to try a new area of the law. But those are, ironically, all of the things that make you a better in-house attorney. Just all of the know-how in areas that maybe are outside of your immediate area of practice, so that you can, when a client comes to you, not just issue spot the IP issues, but say, hey, there's also this data and privacy issue. You might want to talk to our cybersecurity team about this information security issue I see. Hey, by the way, there's an antitrust issue. Whatever it is, I think all of those things just make you a better in-house attorney, being able to do a little bit of everything.
All right. So the last topic I want to discuss is I've been doing this podcast for a while, and one of my first guests was Josh Malone. He's inventor of the Bunch of Balloons, the number one outdoor selling toy in America. It's sold in Walmart and a bunch of other places. But he has a story where when he found out his toy was infringed, he drove his car down to Little Rock and he walked into headquarters. And he was like, please help me stop selling this infringing product. And the reason I bring up this story is because his experience isn't that unique. Probably most people don't do what he did. But they come up with something and then they see their idea being sold on Amazon and so forth. And Amazon was getting a lot of grief for that. And so they set up a patent enforcement program, which I think at least allows people a venue to vent their frustration and at least to take out some of these products. Walmart has decided not to do that, at least for now. From what I understand, Walmart still wants the court to make a judgment that a patent is being infringed before they stop selling a product. Can you share about why Walmart reached a different conclusion about how to handle this problem?
I will say first and foremost, we absolutely respect the IP rights of third parties. That is incredibly important to me. I don't think I could appropriately protect Walmart's IP if I didn't strongly believe that third parties' IP is just as important as our own. So I guess let me say that first and foremost. With respect to any first-party items that we sell, whether online or in-store, to the extent that they are Walmart private branded items, we really attempt to be very mindful about what we're selling. We do IP reviews and clearances, and we never want to be infringing on anyone's IP. With respect to what I think you're referring to, which is Amazon's online marketplace and Walmart's online marketplace, similar to Amazon, we do have an IP claims portal. So you can make a claim about trademark infringement, trade dress, counterfeit, copyright. There is also a form for patent infringements, both design and utility. What we ask is that when a claimant is making a claim about a patent infringement or that their design patent, whatever it might be, is infringed, that they give us evidence of that infringement in the way of decision at a court. Amazon has gone a different direction. For a long time, I believe they had a pilot program where they were allowing folks to basically put themselves at Amazon's disposal to go through this Amazon tribunal and make the case for patent infringement, have some sort of independent third party, I think, vet, along with Amazon in-house counsel. To be honest, in terms of the efficacy of that program, I've really heard and seen mixed results. And so in my mind, in order to really ensure that claims are being heard in a tribunal that has expertise in that, we really ask that you have gone before a court in order to obtain that judgment. To be honest, I'm not sure that anyone wants Walmart saying, oh yeah, this is a patent infringement. That's just not Walmart's area of specialty. I think that would actually raise a lot more concerns. And so what we ask is, if that particular item maybe it was being sold by a different supplier, but if that particular item was found to be infringing, then look, we are happy to take that judgment. We're happy to take that opinion and apply it. But I don't want to be putting Walmart in a place where we're saying that, hey, Walmart's taken a look at this and we've said, yeah, we're going to foreclose the market to you because we think that there is infringement. It is obviously, as we all know, it's a detailed technical undertaking in order to be able to determine whether there is infringement occurring. There needs to be an opportunity to respond. There needs to be opportunity to hopefully make expert declarations and have experts opine. It's just not something that I think a retailer like Walmart at this time, who knows, maybe things will change, but at this time, I don't know that it's something that we would want to undertake on our own.
Yeah. My understanding is that, at least at Amazon, the way it works is there's third-party sellers who know they're selling infringing products. A lot of them come from a big country I won't name, but they pop up there, they sell them, and then when somebody files, obviously, a good faith claim, that third-party seller doesn't even bother responding because they know they're infringing. So Amazon just takes down that product, and maybe it's somewhat of a whack-a-mole game, but at least it provides a realistic process to do that. I heard from even bigger companies that there's no way a company can afford to go after each one of these little infringers or third-party sellers. If investment you have to make in litigation wouldn't justify that, even if you could theoretically track them down somehow. I mean, does that concern you, that it almost seems like, and I know from everything you said, you're obviously a believer in the patent system, you're a believer in innovation, a believer in protecting that innovation. Does it concern you that there's some cracks where third-party sellers are getting away with infringement because they know how to play the game?
I understand what you're saying. I think there are holistic ways to tackle this problem. I don't think Walmart needs to be the federal circuit to do it. One of the ways in which we tackle this problem is that we are very careful in terms of vetting the third-party sellers that we allow onto our platform. Can we be better? Absolutely. We're always looking at ways to be better. We want to make sure that we only have reputable sellers on our platform. And I think that's one way to tackle it. We're very selective about who we let on.
Are you open to demonstrating that somebody's not a reputable seller because of the practices they're engaged? Is that something I guess Walmart is open to hearing from innovators who think they're getting ripped off there? Is that?
Yeah, sure. I mean, I think, look, if there are reasons to believe that a seller is not a reputable seller, all of those are things that our trust and safety team take into account and would want to know.
There's probably going to be lots of people in different stages of their career listening to this, and they're like, wow, Sri has such a cool job. She's the Chief IP Counsel of one of the greatest companies in America. What advice would you give to somebody about following your path?
Oh, gosh. I would say have faith in yourself. I think so many times we sell ourselves short. We think that we can't do something because we haven't done it before, but we'll never know until we try. So my biggest piece of advice is don't take yourself out of the running too early. I would say just have confidence in yourself and have the belief in all of the things that have gotten you to where you are in terms of getting you to your next step.
Sri, thank you so much for joining Clause 8. I really appreciate your time.
Thanks, Eli. I really appreciate it.
Thank you so much for listening. Don't forget that new episodes of Clause 8 come out every 2 weeks, so be sure not to miss it by subscribing at clause8podcast.com.